अनुरोध करुचे से युक्त निरंजन पट्टनायक जी आमर अध्यक्ष अनुरोध करुचे से पुष्पगुच्छ दे स्वागत करेंगे अंगवस्त्र पुष्पगुच्छ दे स्वागत करेंगे एवं आमे जो उपहारटी गोटे ओडिशार गर्व कोणार्क चक्र प्रतिकृति ताको प्रदान करने मु अनुरोध करुचे रामकृष्ण पंडा जी आमर परिचालना ट्रस्टी अनुरोध करुचे। एवं गणतंत्र प्रमुख स्तंभ न्यायपालिका को एवं से प्रश्न होउची जे राज्यपाल बड़ ना विधानसभा बड़ एवं जिते बड़े फेडरल कथा उठुची बा संघीय व्यवस्थार कथा उठुची सेते बड़े इटी संघीय आमे जो विषय रखीचु जे आम संविधान केते संघीय तेणु सेते बड़े ए प्रश्न अति गुरुत्वपूर्ण हो जाउची एवं से प्रश्न विषय रे विस्तृत भाव में कहिबे Justice J. Chelameswar. Now I request Justice J. Chelameswar to deliver his memorial lecture on the memory of Comrade Loknath Chaudhary on the topic, and I think we should be enlightened by his speech, and we will most be thankful to him because he has come here and to deliver this speech on this auspicious occasion. So I request Justice J. Chelameswar kindly deliver his speech.
A very good evening to everybody assembled in this hall. I'm told by Mr. Ramkrishna Panda, family members of late Sri Loknath Chaudhary, eminent men and women of Odisha who were or either are associated with the affairs of the state of Odisha in different capacities, as members of the bureaucracy, as members of the political spectrum of Odisha, and of course the political party to which late Sri Loknath Chaudhary belonged. My respectful pranams to every one of you. When I was invited to deliver this lecture, of course necessarily the question arose, what should be the topic on which I should speak. Well, since it is a memorial lecture, I thought I would choose a neutral topic, not directly concerned with the current political questions. But Mr. Ramakrishna suggested that I should address this gathering on the problems of federalism in this country. Since it is their invitation, I had to defer to his views. I accordingly agreed. I chose the topic, how federal the Indian Constitution is. I'll try my best to analyze it for the benefit of the gathering here. I'm sure people who are associated with the administration of the state and part of the country have their own understanding, views of the federal nature of the Indian Constitution. My views need not necessarily always coincide with the views of every one of you sitting here. I may be pardoned in case if anyone of you is not able to agree with me on my views. With this caveat, I'll proceed with the program today. For the last 75 years, ever since this country has become a republic, we, the people of India, are made to believe that the constitutional structure and the governance of India is federal in nature. Though the Supreme Court from time to time qualified it by saying it is not really federal, but it's a cooperative federation or a quasi-federal constitutional structure. Now, whatever they mean, we'll examine it a little later. Before we go into the legal debate about the constitutional structure, let us first try to arrive at a definition of what is federalism. It is not one of those words which is defined very clearly in the political sciences anywhere. Loosely defined structure. Most of the countries in the world today, when they talk about federalism, they have the American federal model in their mind. And they assume whenever somebody talks about a federal government or a federal constitution, all the attributes or all the structures or arrangements available in the American constitution are equally available to other countries. I am sad to say this, it's not the truth. For various reasons. First of all, federalism, to the extent I understand, based on the American experience and the American constitutional structure, is the voluntary coming together of different political units. I hope I am audible to the last rows. Thank you. See, if you examine the American constitutional structure and system and examine the American history, it's a voluntary organization of different states, to start with 13 states and now it's more than 50. Voluntarily forming into some kind of an association, political association or administrative association, for achieving certain common goals, like primarily the security of the people of these various states against external or internal disturbances, and also to establish an administrative system where the interests of more than one state or number of states or all the states are involved, but not the exclusive interests of one state. It is broadly the American constitutional structure, because we are not having a seminar on American constitutional structure. I am only indicating what it is. Now, insofar as India is concerned, if we recollect our history, prior to the formation of the Republic and the advent of the Constitution in 1950, we don't have to go to the days of Ashoka or Gajapatis of Odisha. I am not going that far. We take the history of India, the constitutional evolution, the constitution of which we are talking about, under which we are governed. Incidentally, we hear nowadays a lot of rhetoric going on at various levels, that we should get rid of the colonial legacies and colonial past. Wonderful. We would like to, but question is, the whole constitutional system and the Westminster form of government which obtains under the Indian constitutional system is fortunately or unfortunately is a colonial legacy. If you don't want the colonial legacy, the ideal thing is abolish the parliament, abolish the legislative assemblies, hand over the administration. Maybe somebody from the old Ganpati family is still there, continuing there, must be there, enters the administration to that family, administration of Odisha to them. There are innumerable Rajas and Maharajas in this country those days. Well, this form of some kind of a democratic structures might have existed in ancient India in the rural janpads. I am not talking about the governance system as it is occurring under the Indian Constitution today was not there. And when the Republic was formed, only roughly 2/3 of the territory of present India, what we call India today, was directly under the rule of the English. I'm sure most of you know that. Rest of the 1/3 was ruled by different principalities, states like Hyderabad, the Mysore, so on and so forth. There are innumerable, about some 506 Rajas and Maharajas. 1/3 of the territory was under their control. And each one of these territories had a different legal structure or administrative structure. So there's a big study by itself. Even this 2/3 territory of what we call India today, which was part of the British India, which was described as British India, which was under the control of the East India Company to start with, and later went under the control of the British, technically the Crown, though the Crown was only titular head under the British parliamentary system. There were administrative divisions of the territory of this country. It all started with 3 provinces. Madras province, what we call Chennai today, they call it Madras. The province was called Madras province. The Bombay province and the Bengal province. There were 3 provinces came to be called presidencies. All other provinces came much later. The central provinces and northwestern provinces, so many things. Some 14 provinces came at some point of time. And the different sets of administration and constitutional setup was existing in each one of them. Broadly, though there were differences, broadly the administrative system and the system of governance in the presidencies in the provinces of Madras, Calcutta and Bombay were similar. And in so far as the other provinces are concerned, there were variations. One distinct feature is that when it came to the 1915 Government of India Act or 1935 Government of India Act, the governors of these 3 presidencies, Madras, Bombay and Calcutta, were appointed by the Crown, the king or queen at the point of time, who was the Crown that time, by a sign of the Crown. Whereas the governors of the other provinces and provinces of the left, there were some provinces called Lieutenant Governors provinces. These people were appointed by the Secretary of State or Viceroy. From time to time it kept varying with the approval of the monarch. So within that, even the British India, the structure was not really uniform. And there were only all these various units, these provinces, the presidencies or the non-presidency provinces. they were looked at as only administrative units for a long time. Some attempt was subsequent to the formation of the Indian independence movement in the later half of 19th century. Proposals for reforms of the administration started. The British government slowly thought of creating some kind of a self-governance by the Indians. It was a very elementary proposal they made. The freedom fighters were not satisfied with it. Then, I'll not go into the full development of the thing, it's not the place for that. Then came the Government of India Act. The expression federation appeared for the first time in the Government of India Act 35. And the federation which was contemplated in the Government of India Act, and for my dear friends, for those who are not lawyers and who are not examined these legal documents, I may tell you, in the text of the Indian Constitution on which we are governed, the expression federation doesn't exist. India is only union, whatever it means. You may attribute whatever, you may give whatever meaning you want to give to it, but the expression federation is not used in the Indian Constitution today. 1935 Act, Section 5 of the 1935 Act, those days they were called sections, now we call articles of the Constitution of India. For the first time used the expression federation. And what was this federation contemplated under the 1935 Act? That federation contemplated there was the provinces of the British India, either the governor's provinces or lieutenant governor's provinces, whatever are the provinces, the 2/3 of what we call India today, and the princely states which vowed their allegiance to the British crown. Now, the legal structure proposed under 1935 Act is that all these bodies put together would form a federation. That is the understanding of 1935 Act of the word federation. For whatever good reasons, the Constitution omitted that expression federation. It's not there. But the point is, as I mentioned to you to start with, conceptually what is a federal constitution or what is a federal country is a very mystical concept. All of us have a concrete example only of American Constitution and American governance system. If we take that to be the standard federal model, if we take it or not is up to each one of you to decide. It's for the people to decide. But if most of us generally believe on proceed on notions that it should be so, when it is not meeting our expectation in any one of its administrative activities, then immediately we say the federal spirit is violated. Well, there are opinions. Question is, as long as this country was under the British rule, either under the rule of the East India Company or directly under control by the British Crown technically, British Parliament, India was India was always treated as one unit, political unit, with different administrative units which are subordinate to the, I'm deliberately using the expression subordinate, I'll explain why I'm using it, subordinate to the main unit. The reason is this, from time to time, examine at least 1935 Act, we don't have to go before that. Though that question, of course, Mr. Honorable, you raised about the governor's question. I'll discuss it in detail later, but it has relevance in the context. The 1935 Act contemplated some kind of a legislative bodies in the provinces as well as the central level. This expression central government once again starts from there. The Indian constitution doesn't use the word central government anywhere. It's of the government of India, union government. But then it's an old expression which continued in the administrative jargon of this country. Now, under the scheme of the 1935 Act, when the local legislature passes an act, it had to be presented to the governor, of course, just as it was presented in the Westminster system to the Crown. It had to be placed before the governor. Governor had provincial governor. Governor had three choices: either assent to the bill or withhold the bill. The whole controversy is going around that withholding today. Or refer it to the assent of the Governor General. Well, one particular expression, of course, for lawyers, language matters in interpreting the law. Common man's understanding of law is something different. And politicians have a greater elbow room because they mold the history, they mold the law, they have an opportunity of dealing with the molding the law. Now, the old Government of India Act, Section 75 of that Act, which invested the governor with the power either to grant the assent or withhold the assent or refer it to the Governor General for his assent. And the governor in his discretion could do any one of these things. Now, what is meant by withholding the assent in the context of Government of India Act 1935, we need not worry today because it is a dead and gone this thing. Significantly, under the Constitution of India today, the corresponding article is Article 200 insofar as states are concerned. Parliament is a different story. We need not really worry about it in the context of federalism. Parliament and the authority of the union government in cabinet they stand on a totally different footing. The dimensions are different. Insofar as the states are concerned, because we are talking about federalism and federal structure, federal rights and so on. This word discretion is not there in the Constitution today. What was there in 1935 Act is not there today. Now, under the old system, if the governor for any reason under Government of India Act 1935 decided to refer it to the Governor General, Governor General may either grant his assent or may reject his assent. But at least the Government of India Act made this much of a rational provision. The Governor General, when he rejects the assent, he is required to communicate to the governor the reasons why he is doing it under the Government of India Act. Unfortunately, under the Constitution of India, if the matter is referred to the President, there is no express provision. Now, one thing is, everything is not said in any constitution, any Indian, for example, Indian Constitution is a very long document. American Constitution is 1/8 or 1/10 of the length of the Indian Constitution. Everything is never said in the Constitution. Lot of things are left to the practices. In fact, an American scholar, a professor in constitutional law, makes a fantastic observation. They're all meant for lawyers. How far they will be relevant for common people, how far we have educated them or educating them is a different matter. It's for those who are directly involved in politics to think of. He said, in the context of American Constitution, which is true of any constitution, the Constitution is an intentionally incomplete and deliberately open textured document for the participatory evolution of democratic practices, he says. Everything will not be said in the Constitution. There are certain things which evolve over a period of time by virtue of democratic practices in a democratic society. And another aspect is the silences of constitution themselves. A lot of legal analysis and scholarship went into constitutional law all over the world, at least wherever the democratic constitutions function. It is said that constitutional silences are equally important. If the constitution is silent, it doesn't mean, say, for an example I'll give you. I'm sure friends from the media are present here. All of us broadly believe, from lawyer friends, I don't have to explain, non-lawyers. Forgive me if I sound a little condescending. All of us believe that we have a freedom of press in this country. And my dear friends from the media, there is nothing in the text of the Indian Constitution which guarantees freedom of press. It is the silence of the Constitution. It's a derivative of the freedom of speech, which is an express provision of the Constitution. From that, by an interpretative process, the Supreme Court laid down that freedom of speech necessarily, freedom of speech, is all right? Am I audible? At this yeah. Freedom of speech necessarily takes within its field the freedom of press. Ultimately, freedom of speech means what? Within the four walls of my room, my privacy of my room, I can talk anything. I can give the most horrible galis to anybody whom I don't like. I have that freedom of speech. But then the problem is, giving galis is a civilized thing or not, cultured thing or not is a different matter. Okay, I'll not say galis. I can criticize. I can criticize anybody, any system, any government, any policy, I can criticize. But if the criticism is in the four walls of my room, nobody else is there, it's only a waste of energy and my breath. Only when I am able to communicate it to others and able to convince others, this freedom may mean something. So therefore the freedom of speech is assured. And then necessarily freedom of course, by the time the Constitution was drafted, the TV and internet were not known to India at least. Internet was not known to the world. Even TV was not known to the just elementary stages, it was not known to India. Predominantly the print media, their rights came before the courts from time to time. Now why I am saying all these things is, merely because the Constitution is silent on a particular aspect, it doesn't mean the Constitution does not convey anything. How to understand it? What does it mean? What is it trying to communicate? Is a matter for a deeper analysis which is possible for those who make a systematic study of the constitutional theory, the interpretation of the documents, so on and so forth. There are various factors. Without meaning any disrespect to anybody, a layman who is not trained in law at the outset will be a little perplexed about some of these things, especially when these concepts are not to his liking. He'll immediately say, "No, it is not there." Very frequently heard accusation, "I am conscious of my limitations. I was a dissenting judge in the NJSC matter." That's a different story. I am not on that. But very frequently, a lot of people from the public, people in public life, particularly active politicians, make an allegation that India is the only country where judges appoint judges. It is only a partial truth, my dear friends. Now, why did that situation come is a different story. We reached a state sometime in late post-1980, the significance of 1980, all of you know in the political context of this country. The government of the day started, the original scheme of the Constitution is, the Constitution required government to appoint judges in consultation with the Chief Justice of India. And then as a practice, the recommendations used to emanate from the High Court Chief Justice. Matters went to the Supreme Court. Then the usual exercise, of course, the Government of India used to, a judge or a Chief Justice of the High Court or Supreme Court may know the legal expertise or lack of it of a lawyer, whether a lawyer could be considered for judgeship. That much judges are expected to know because lawyers appear before them every day. We know whether he's a good lawyer, not a good lawyer, so on. But what is the other aspect of the person, the man or woman? His ethical values, his social beliefs, his social conduct. Whether a person is a habitual alcoholic or somebody chronically indebted. It would be an embarrassment. If you pick up somebody, maybe somebody is a brilliant lawyer, but then he owes 10 crores of debts to all over the people, all over the country. You make him a judge from tomorrow, it's going to be a great embarrassment. So, to prevent all these things, government undertakes a checkup about other aspects of the suitability, what you call broadly suitability of a person for elevation. This was the system when the constitution was drafted. The framers of the constitution, mind you, most of them barring perhaps a few, were men and women of sacrifice, knowledge. They had seen what was happening all over the world, the struggle for democracy. All those things, they expected people occupying such positions at the highest level would act more responsibly and more rationally. Therefore, they didn't say that, in fact, there was some debate in the Parliament, the Constituent Assembly, whether the Chief Justice should have exclusive say in the matter. Baba Sahib said no, however great the office is, Chief Justice also is a human being. To invest such power in an individual is not right. It must be distributed. It must be a consultative process. Ultimately, whether we understand today or not, to what extent we understand, this division of powers between the legislative bodies, executive government and the judiciary is the outcome of a theory of distribution of powers originated sometime in the 18th century, a man called Montesquieu. The idea is that concentration of all the state powers in olden days, in the days of absolute monarchs, all the powers were concentrated in one person. The monarch, the king, the Chakravarti could make the law, whatever is the law he believed, not subjected to any discussion, any debate, no assembly, no shouting, nothing of the kind. The king could make the law, he can execute it, he can call his soldiers and say, go and behead the man, do whatever you like. That kind of a power is not congenial for the liberties of the people. History has enough examples of all this. So, a theory was developed that power should be distributed. The legislative power, the executive power, and the judicial, all this power collectively is part of the state's power. These three are co-equal branches sharing the power of the jurisprudential entity called the state, distributed, so that each one of them counterbalance the other branches. No branch misuses the power, abuses the power, because all abuse of power would eventually result in detriment to the liberty and happiness of the people. That was the idea with which this concept was developed. So it was in this background, when the Constitution said, in consultation with the Chief Justice, the framers, as I told you, as all of you, we know, most of them were men of sacrifice, men or women of sacrifice. They expected the later generations who would be entrusted with the enforcement of the Constitution to act responsibly, rationally, not based on narrow partisan or personal considerations. Then sometime in 1980s, situation changed. The government of that day started tinkering with the selection process. And there have been instances where appointments were made even without a formal information to the Chief Justice of India. Forget about consulting or concurrence of the Chief Justice of India. Not even information was given to them. Second judge's case by which the collegium system was propounded was a consequence of this state of affairs. Please remember, all law arises out of human experience, human history. Take any law. It has some background in history, it's experience of the society, some problem which the representatives of the society in a democracy wish to solve. And they devise their own right or good or not so good, they devise design, they make a law. It happens. Same thing happened when this question came, when this became a very troublesome feature of making appointments without even informing the Chief Justice of India. The backlash was the second judge's case under which the collegium theory was propounded. In fact, Justice Verma, who was predominantly the author of the judgment, makes in one of his penultimate paragraphs, he says, the whole exercise is not undertaken in the spirit of winner takes all. It is an exercise to be jointly undertaken by the legislative, the executive and the judiciary to identify the best person for the office. That was if you keep that in mind, all these questions, all this rhetoric will not come into. Now, as human experience shows, political philosophers said, power corrupts. All forms of corruption, including judicial power, corrupts. Once the power came into the hands of the judiciary, there have been instances where very undesirable people have been elevated on very wholesome considerations. I don't want to go into the details, it will be very unpleasant to talk about names and people. But yes, quite a few of them happened. In fact, I indicated in my dissenting judgment. Now, the point is, this is how the interpretative process goes on. In this process, if the dropping of the expression governor in his discretion, which occurred in the Government of India Act, which is not there today in the Constitution of India, must have some significance, some meaning. So it is a matter to be explored and interpreted. And under the system, interpretation of the Constitution and the laws is the job of the judiciary. That's how the interpretation started. I'll come to that question later. Broadly, I'm indicating the area. Now, the point is, we're talking about federalism. What are the factors which constitute a federal political entity? Different units, geographical units, getting together to constitute a larger body for achieving certain common good, like the defense of the people and all those things which are incidental to the nation. And when different people, different geographical units and inhabitants of those units get together voluntarily, necessarily they surrender a part of their sovereign authority. In olden days, the sovereignty was believed to reside in the monarch, one individual. Those days are gone. For the last few centuries, when the democratic politics have taken root in the world, people come to recognize ultimately it is the people It's the people who are sovereign. It's their power which either a monarch exercises or an elected prime minister or chief minister exercises. It's the power of the people. Now, but what is this? Was it a voluntary association in India? I have my own doubts. The entire freedom movement was essentially a movement against the rule of a foreigner. Beyond that, most of the common people never thought of anything beyond that. No, the people like Gandhiji or XYZ, Nehru, whoever was the leaders of the movement those days, they were educated in the Western system, they had a better understanding of all these things. But for a common man, what simply meant was rid of the white man. That was the only requirement which drove the masses of this country. Once that is achieved, for whatever we have indications in the Constituent Assembly debates, the framers of the Constitution were a little worried whether this country, after losing the British government, throwing out the British government, would still survive as a cohesive body, because we have seen in our own lifetimes all kinds of divisive attitudes in this country. Because the country is such, there are innumerable divisions based on caste, community, language, region, religion, so on and so. Think of it. If there is none, we will invent some politics, political party. Anything can be a good ground for dividing people in this country. Well, that's human nature all over. Maybe it happens in different names in different countries, but in this country also it happens. Well, here I enter a caveat. I would rather be careful about what I am going to say. For a long time, including the last Winston Churchill and many people before him, the British prime ministers, the British administration, very strongly believed that Indians are incapable of ruling themselves. That was a belief which they thought that they are more competent, more knowledgeable, they are more politically aware. Only they have a responsibility to rather uplift the expression those were the gentles. Maybe at the time of the formation of, I told you, without any malice or without anything, I have a suspicion maybe that belief still lingered. When it comes to the states, the arrangement under the Constitution, the same arrangement which continued under the Government of India Act, the governor, see, if the governor is supposed under the scheme of the Constitution. First of all, why do we have governors is another question, whether it is required or not. You have heard the senior politicians in this country occasionally shouting, abolish the post of the governor. That's another story, I'm not on that. But as the Constitution exists today, there is a governor, he is part of the legislature. A bill becomes a law only after receiving the assent of the President. Then I fail to understand the rationale behind investing that some kind of a loose discretion in the governor to withhold. That expression withhold is still there in the Constitution. Now, that must be given some meaning. Withhold for what reason? If the governor perceives, let us say, that a particular bill is totally beyond the competence of the state legislature, it deals with the subject which is exclusively the subject assigned to the parliament. If the governor entertains such a doubt, there are ways of ascertaining the correctness. You can say legal advice, there is an advocate general. His opinion, or you can consult anybody else, any other lawyers are there. You can ask the attorney general. Some concrete ground on which the governor may entertain is possible. It's not necessary that every time whatever the majority decides is right in law or fact. The greatest example for this, the whole idea of constitution and guarantees fundamental rights is this. All of us would have heard of Socrates and the story of Socrates. He was killed by the state by administering poison, a poison called hemlock. Why was he killed? It was believed that he was propagating wrong ideas, spoiling the youth. Therefore, he is a menace to the society, he must be killed. Wonderful, that's a different matter. But the point is, who took the decision? It was not an individual judge like Chelameswar XYZ or something like that. The entire citizenry of Athens gathered, a small city-state of Greece. Entire citizenry gathered and they declared that this man is propagating bad ideas. And he was duly killed thereafter. Socrates was a great mind by the standards of his own times. Not that everything he said was gospel, there were modifications only, but it was a great mind certainly. So therefore, merely because the majority decide he should be killed, it doesn't become right. It may be the most democratic act because all the people participated, not an individual judge nominated by the president or the chief justice of India. It was the people of something we have been hearing in the last 30 years, the Taliban type of trials. People gather there and decide it. Something like that happened in all Greece. It didn't start with Taliban, it started much before in Greece itself. So therefore, this majority opinions, majorities are transient. A political party which enjoys a tremendous popularity at a given point of time may at a certain point of time later lose that popularity. We have seen before our own eyes various political parties all over the country. So therefore, don't make it dependent purely on the temporary opinion of the masses. Sometimes masses are swayed away by emotions and politicians can comfortably, I'm sorry, I don't mean any personal offense, Mr. Panda. But then we have, history has seen, all of us who have read the Julius Caesar drama, remember those fiery speeches of Brutus and Mark Antony. Within minutes, the opinion of the public changed because they could sway the views of the public. So, to protect people against such dangers, this whole constitutional system and the constitutional documents, this idea was invented, where certain fundamental values which can't change with majority opinion of the day. The majority may change tomorrow, they may hold a different view. But even then, right and wrong can't depend purely absolute in the sense certain basic values can't depend whether the government should give 2 rupees a kg rice or free cell phones or not. Well, it may be a matter of choice. Whether I should have a fair trial. Suppose tomorrow somebody were to accuse me. Look here, Chelameswar gave a speech which is a criminal act. There must be some independent way of deciding whether there is anything criminal about my speech. Those are the higher levels of values which are contained in the Constitution. Now, if that is the system, this process of it's simply borrowing and copying from the Government of India Act, is not an indicator of the fact that the Constitution of India really wanted a federal political system as it occurs in America. It may be a different brand of federalism in this country. Whether it's right or wrong, well, finally it's for the people to decide later. Now, one more indicator. We have, I'm sorry, there must be some, I'm told there are some retired bureaucrats here. I don't mean anything personal against any one of them. Not that I'm afraid, but I'm just making my We are still happily continuing with the old system of IS. See, if we are really federal, why should an officer recruited by the government of India who is subject to the disciplinary control of the government of India deal with the affairs of state? If in a federal society, in US it doesn't happen. The officers appointed by the federal government deal with federal subjects like defense or let us say currency, XYZ. The federal structures only for that, or federal taxes. The taxing system is different. The state taxes are different in US and federal taxes are different. The officers are appointed by the Federation, the American Federation, deal only with those subjects. Here that distinction is not there. An IS officer, a police IPS officer appointed by the government or the machinery created. Listen, they are ultimately under 309. They are employed by the President of India, technically. Why should he be? No, they are happy with it for 70 years, let them continue. I am not on that. But to indicate that this is certainly not an indicator of federalism in the country. Two. Third indicator. In federal constitutional structures, the legislative powers are clearly demarcated. In America, the federal legislature has enumerated powers. A limited number of items are included in the enumeration. In India, we have 3 lists. One union list, one state list, one concurrent list. Whatever is the necessity, that's a different matter. I am not entering a full-fledged discourse on it. But what is more relevant is, even among those items which are the state list under list 2 of the 7th schedule, at least 5 or 6 items, once again, are made subject to the law made by the Parliament if there is a declaration by the Parliament that it is a matter of national importance. So it can keep varying. If really the constitution makers believed that these are matters of national importance and therefore the state should have no say in the matter, right or wrong, that's a different, their wisdom. They could have simply made, you have included 97, 96 items in the first list, and the residuary power of 97 of the first list is always there. And assign certain things. One example I'll give you, which perhaps people in Odisha will more easily understand. Laws dealing with mines and minerals and taxes on mines and minerals, mining activity, are essentially under the list 2, entry 23 and entry 50, if I remember right, if my memory is not failing. But then both the entries are made subject to a law made by the Parliament in excess of the power under entry 54 of the first list. So what you give with your right hand, you take it off. 1957, the Mines and Minerals Development and Regulation Act was made. All major minerals, whether they are available in Odisha, Andhra Pradesh, Gujarat, Kashmir or any other place, eventually the control is with the government. And please remember, it's a major source of revenue for any state, in any country. Most of the wars which we notice, apart from the rhetoric, the wars are fought for resources. Whether whether Russia is waging a war against Ukraine, or some time back, or America is trying to control Iran, the major idea is, they may talk about democracy, anything, whatever it is, that's not the point. The idea basically is the resources, the oil, the coal, the resources. Because they are the most important things in modern industrial world. Those days, by the time the East India Company came, all these things were not there. Agriculture land is the most, when Karl Marx wrote the theory, the major source of revenue is land. Therefore, the whole theory revolves around land, labor, capital, so on and so forth. And then if Marx were to write the theory today, I don't know, it would have been a slightly different theory. So, what is given with the right hand is taken away with the left hand in the distribution of legislative powers. This is one more indication that perhaps India is not a real federal country, or the constitution is not a federal constitution. And I think time is running out. And come to my own judiciary. People, all those fine gentlemen and ladies who talk about judges appointing judges happens only in India. In America, a judge in a state court is never transferred to some other state. It happens only in India. And unfortunately or fortunately, what I don't want to add any adjective, it is a brought over from the Government of India Act. Because the British looked at the judicial system and judges on par with the ICS or IPS officers. Whether they are equivalent or they are better, I am not going into that question. But the members of the judiciary were treated alike by the British. We borrowed that. We have a specific provision in the Indian Constitution regarding the transfer of judges. And this kind of a power can be used for the right purposes or wrong purposes. And more often, in my personal view, I may be wrong, I may be corrected, more often this power is used for wrong purposes by any government, anywhere in the world. Because independent judges are a nuisance for any government. So, we can always hold the thing, transfer is something. No, even for officer, but then for an officer, he has an opportunity of going and challenging his transfer before the court, so long as the legal system is intact. For a judge, that possibility is not there. It is shut down by the Supreme Court. You can't question it. Maximum, you can make a representation to the Chief Justice of India, or if you have enough connections, you can manipulate here or there. Some Supreme Court judge, you can go there. And so the point is this very fact that now. What was the reason? Eventually the provision was there. Very rarely for the first 30 years judges were transferred. Very rare occasions. Genuinely in the interest of the administration of justice, some transfers were made in the first 30 years. In 1980s, when this transfer policy was introduced as a policy, the then law minister, incidentally he comes from my home state, not today my home state, earlier my home state. He made a speech, thunderous speech in the Lok Sabha. I don't know, Mr. Loknath Chaudhary was a member of those days, 80s?
No, he was 99 to 96.
Achha, okay. He made a speech saying that chief justices are becoming, they're building empires of their own clan. There are courts in this country belonging to X community, Y community. So there is some truth in it, and it's not an absolute falsehood, there is some truth in it. But the remedy appeared to be worse than the disease. And that second question which I would ask, however bad or unwholesome a Chief Justice is in promoting his own kith and kin, does a Chief Justice enjoy much greater power than a Chief Minister? If that is the consideration for transferring, I think Chief Minister also should be transferred. Wherever there is a complaint, Chief Minister also should go out of the country, that particular state. And I think the logic is not, that's all I'm trying to say. I'm not saying it's not possible. But this can be it can affect the independence of the judiciary to some extent. That's a different topic altogether. But point is, these are all indicators of this fact that it may not be a federal constitution, at least if we take it on the model of the American Constitution. It is a federal constitution of its own kind. Whether it's good or bad, whether it's serving us well or not, and it's for the people of this country to decide. And how to deal with it is a different story. I think I would stop my speech here. There are two questions now I'm bound to answer. One is one nation, one election. Sir, whether it is a practicable idea or not is a different question. Personally, I believe it is not a practicable idea because we know how the governments are formed and how the governments fall in this country. We have seen for the last 75 years. So, in which case, making the whole life of the legislative body, coterminous with the life of the parliament doesn't make, even the life of parliament, okay, for the last 10 years it's all right, first 30 years it was all right, it ran for full 5 years. But there was a phase after 1989 till 2014, the governments at the Delhi level, central governments, so-called central governments, they lived with the skin of their teeth. And what all circus went on, we have seen. In this background, whether this experiment would succeed, I have my doubt whether it will succeed. No, whether legally it is tenable or not is a different matter. Legally, if the parliament decides to amend the constitution, I personally don't see any difficulty in law in that. Whether it's a wise thing or not, it's not for judges to decide. That's where I defer to the wisdom of the elected members. It's for the people and their representatives to decide whether this is it is a desirable thing or not. That's all I can say. Then about the presidential reference, the second question posed by me. This is a tricky area for two reasons. As a former judge, I am bound still by some discipline. The matter is now before the Supreme Court. But I can always, as a citizen, I can always express my view. 143 or 142, relevant article is 143, I think, numbers. Authorizes the president, when the president is convinced there is an important question of fact or law, which requires the elicitation of an opinion from the Supreme Court. The text of the Constitution certainly authorizes the president to make a reference. But the question is where the field is totally unoccupied, there is no answer, or whether in the field there is a judgment and which is highly doubtful in the views of those who are trained in law. A reference can be made, power certainly is there by the president. But the question is, when a bench of the Constitution, the Supreme Court, declares the legal position, and I can say with this much I can say as a lawyer, as a former judge, I have gone through the judgment very carefully. I don't find anything wrong with the judgment. In fact, questions are raised, how can they direct the president or the governor? With anti-democratic forces, somebody described, some gentleman in a high office described anti-democratic forces. What I try to understand is, if a bill passed by the Legislative Assembly, elected members of the people, representatives of the people pass a bill, and one nominated governor can sit on the bill for 3 years, it doesn't appear to be anti-democratic. No, the bill may be an absolutely bad bill. It is to be examined independently. Then it would have been an ideal case to refer it to the Supreme Court's opinion. In that case, not sitting over it for 3 years. That doesn't appear to be anti-democratic to them. But then when the verdict goes against them, everybody is agitated. Let us see what the Supreme Court decides. Because the reference is before them. 2 judges have clearly spoken, sitting judges, saying that this can't be done. Whether the other, now it is to be heard by 5 judges minimum. Whether the other 5 judges also will give the same opinion or not, I can't speculate. I am no astrologer on that. But my personal view is, the reason is simple. Once again, starting about the colonial legacy, it is exactly the colonial legacy. The king can do no wrong was a doctrine in English law. The king can never be subjected to a judicial process. But that is not the case in a democratic society. Every public office holder is answerable for every discharge or non-discharge of a public function. He is answerable to somebody. Primarily answerable to legislative bodies, the parliament. Unfortunately, in a democracy governed by party system, parties which have majority can simply ignore it. They don't ask the accountability of the executive. First accountability is to the legislative body. But in the party system, that question is not raised. Then somebody else will have to look into it. If the judiciary looks into it, you question it, well, let us see what happens. To my mind, I have no difficulty in believing that the judgment is right. Very well reasoned judgment. One more aspect, in fact, I forgot. Talking about the legislative powers, the finances, the distribution of finances, substantially most milk yielding cows are with the Parliament and the Government of India. I was just checking up this evening before I came here. The revenue for 24 financial years for the Government of India is something like some 33 crores or something like that, both direct and indirect taxes. And the biggest state in the country, UP, its revenue is about 6 lakh crores. And Tamil Nadu is about 3.5 or 3.7, something like that. And how is it then ultimately revenues are contributed by the people of this country in different states? What is their contribution, and why should the Government of India be... Now, Government of India is entitled certainly to get money for running some common constitutional requirements like defense, so on and so forth. But then collect the whole money and distribute it. Well, is it really consistent with the democratic federal structure? Is another question. So these are the various indicators, to my mind, to believe that we are only a federal, we believe that we are living in a federal country. But in fact, I doubt it very much. Thank you.